The Rural and Urban Private Hospitals Association of Kenya has welcomed the ruling by the High Court that the Social Health Insurance Act is unconstitutional. RUPHA argues that the act wouldn't have faced headwinds had it undergone extensive consultations before being passed into law. The association has therefore asked the government to consider staggering the shift from the National Health Insurance Fund, that is NHIF, to allow for, among others, proper funding for the transition.
The entire Digital Health Act 2023 and the entire Primary Health Act 2023 are all unconstitutional for the reasons set out in this judgment.
As the government goes back to the drawing board to realign its health agenda, a section of healthcare providers is demanding broader discussions on how to insulate the new health regime against the afflictions of the National Health Insurance Fund.
The focus of the Ministry of Health has been taken up by the transition from NHIF to SHIF. And as a result of this focus, payments to hospitals have fallen drastically. 29 billion shillings in historical debts that are yet to be reconciled. This was part of the mandate of the Transition Committee. To this day, reconciliation has not been done.
The Rural and Urban Private Hospitals Association of Kenya wants NHIF to negotiate and renew contracts with healthcare facilities under a new benefits and tariffs regime.
While we are extending the time, the transition, we would like that the providers be contracted, instead of a 3-month extension, at least give providers a new 2-year contract. Give providers a new 2-year contract under a new benefits and tariffs regime.
The association says an agreeable decision on the issues raised will help stabilize the health sector and reassure the country that there will be no disruption in the delivery of health services. The High Court declared the Social Health Insurance Fund unconstitutional and gave Parliament 120 days to amend the law establishing the fund. Kasi Chena Masha, Legends Edition.